Alright, as a refresher, recall that in the vast majority of criminal offenses, there are two elements which need to be proven in order to establish criminal liability: the actus reus, or guilty act, and the appropriate level of mens rea, or guilty mind. In English law, it is an established rule that these two elements must coincide. What does that mean? It means that they must happen at the same time. In other words, the defendant must, for instance, be honest at the time he takes property to be liable for theft. In an interesting case, Edwards v. Dean, 1976, the defendant went to a petrol station and filled up with petrol. He then asked the attendant to put oil and water in his car. Whilst the attendant washed his hands, the defendant drove off without paying. It was held that his actions did not amount to theft, as in contract law, the property in the petrol passed to the defendant when it was put into his petrol tank. He formed the intention of not paying later on. At the time of forming the intention not to pay for the petrol, it already belonged to him. In most cases, the question of coincidence will be a matter of common sense and probably not cause the prosecution or any jury too much confusion. However, the matter has been raised in a number of cases, and as a result, the courts can be seen to have adopted a flexible approach to the issue. They developed ways of finding coincidence of actus reus and mens rea when the acts take place over the period of time and when they form a chain of events.